All right, thank you for staying with Daybreak. I see some of your feedback. We'll get them in just a bit at the tail end of the conversation. Let's talk about the BBI judgment appeal right now. We know that the Attorney General, Kiara Kariuki, withdrew the application seeking to suspend BBI judgment. He says that he intends to make similar applications in the Court of Appeal. Earlier on, the High Court had certified as urgent that application, which was then withdrawn. The 5-judge bench have been under fire. They've also been fighting back. There's been a bit of intimidation here and there. Governor Mutu, I'll start with you. Is this, you know, the last time we spoke, we were waiting for the Senate and the National Assembly to vote on the BBI. They passed it, and then the court stopped it. Is this the end of BBI from where you stand? Should it even be pushed further, or just let it be?
No, this is not the end of BBI. I think this is just a hitch on the road towards BBI. It is very important for us to ask ourselves, why do we have these amendments? What came out of it? Maybe, you know, we have short memories. In this country, a few years ago, there was a lot of tension. Raila Odinga had gone and sworn himself as the so-called people's president. And as a result of that, there was a lot of tension in the country. You remember people like Miguna, being shipped out of this country. You know, they say, come, baby, come. And he went away. He's not come back again. And, there was a lot of tension. The market was paralyzed. Economically, we were not doing well. Kenyans were scared. We looked like we'd go back to the post-election violence. Then one afternoon, President Uhuru Kenyatta, Raila Odinga, they stand outside Harambee House and they shake hands. And there was a sigh of relief in this country. And all of a sudden, the country seemed to go back to normality. People forget. Now, as a result of that handshake, they decided, can we try and cure the problem that we have in this country? Why is it that every election, there is all this fighting, all these issues that we are facing, and why is it that people feel like some feel more Kenyan than others? And then they put together a team to go around the country, doing public participation, collecting views. My members of Mandelo Chap from every corner, from Mandera to Lunga, they met, this steering committee. We expressed our views. Nationally, I went there personally. I presented a memorandum. I read the memorandum. We expressed our views about what needs to change in this country. After the whole conversation, it was agreed, then for us to change this, let's make amendments in law, both in written law and also in the Constitution. So this BBI was not formed for two people. It was not formed just out of the blue. These BBI amendments of the Constitution came about because Kenya needed change. And I'm giving some bit of history because at times we tend to forget why it's there. Now, there's a hitch. We saw what happened in courts. I'm going to be issuing a statement today of Mandelo Chap. We've been retreating and meeting with our members. We say, let's respect the courts, but we disagree with the stand that they have taken because they have concentrated on technicalities, not on the form. Because what was the problem we're trying to cure? We've got a huge young population in this country that is unemployed. So what happens to those tax breaks? You look at the development that we've been able to do. For example, if I take Machakos County, with only 7 to 8 billion a year from the national government, plus a bit of collection from my resources, I've been able to build over 200 kilometers of tarmac roads. I've been able to dig over 600 balls of water. I have changed the lives of people. I have Mulikamwizis everywhere. I have free polytechnics. My healthcare is booming. I have a cancer center with very little money. Now, what happens when a governor gets nearly triple that? I'll be getting, Machakos will be getting close to 20 billion with the BBI. That means more money will come from Nairobi, from all those corruption cartels that Senator Cherangai was talking about when asking about the dams, back to the people. So there are all these other principles that the judges should have looked at, but I don't want to touch on them because it's sub judice because it's in court. But I want to say that BBI is not dead. I foresee something. I foresee two things. I foresee one, the Court of Appeal setting aside a large proportion of the declarations made by the lower court and maybe upholding a few of them. So there may be a bit of an adjustment that will be made because this constitutional amendment is not about one person, it's about all of us. But take this to the bank. Take this to the bank. We will have a referendum and come next election, we'll be under new dispensation because finally, BBI is not overhauling the Constitution. When I read the judgment, it looks as if there was a thinking as if we were overhauling the constitution. No, the 2010 constitution remains. What we are doing is basically improving on it. Ni kama gari umeona ya kwamba gurudumu moja ina yumba yumba. You are tightening the bolt. You are changing part of the seats that were giving you a backache. You are adding a better steering wheel to make it better. You are not changing the car. The constitution remains. What you're doing is making it better for the people of Kenya.
All right. Honorable Kelo, what do you think? Is this the end of it all?
Trevor.
Yeah.
Yes. As proponents of the BBI, we know we were shocked by the decision of this 5-judge bench. But moving to the appellate channels, we believe we have a substantial body of evidence enough to turn around or set aside the decision of this 5-judge bench. And we believe that our lawyers will come up with a masterclass advocacy so that we can get our orders. Trevor, as a party, ODM party that has really fought to have these amendments be put in place, we respect the decision of these 5 judges because, again, we also respect the decisions that they make. We do not agree with the judgment, but we definitely respect the decision. And that is why the appellate channels were created. We will be in the Court of Appeal. If we don't get our orders, we are moving to the apex court, the Supreme Court. Doing this with tremendous respect to the judges in the lower courts, even as we move along. You know, one thing that you have to give to these judges, Trevor, and you know, laws are made for posterity, is the fact that they were very independent while expressing their will on this issue that was presented before them. You know, they were very robust. They delved into these germane issues, certain times going off tangent, but at least you can give it to them that they were not fearful and they were in a position to express their will without any iota of intimidation. Mm-hmm. So that is given, and every country needs a progressive and a robust judiciary. We know the former Chief Justice, now emeritus, David Maraga, began this process of creating independence within the judiciary, and I am glad that if this decision is anything to go by, then judges are continuing with that kind of decision. But without you know, being cited for sub judice rule, we definitely know that they tended to drag the president's name, Mr. Uhuru Muigai Kenyatta, into their decision. And the question that we are asking ourselves is, was President Uhuru Kenyatta a respondent in this matter? And was he served duly by the courts? And did he send his lawyer to represent him in this? Because his name was, you know, a part of this decision, but we cannot wrap our heads around a time when he was served with this kind of papers so that he could file a response. And if indeed he was not a respondent in this matter, then this is going to be a germane issue in the Court of Appeal and has the potential to turn around that decision and set it aside. You know, whether President Uhuru Kenyatta is a citizen, ordinary citizen, or not an ordinary citizen, I think this is going to be very interesting in the Court of Appeal. Okay. But the judges also say that he can be sued as an ordinary citizen of the Republic of Kenya, but again saying, you know, it's not very ordinary that he can move a popular initiative. And that brings me into my last, you know, my last assessment. Yeah. If this process is a popular initiative, I mean, what is wrong if we are out here, all of us, to popularize it? The name is about popular, and it does not limit or gag anybody from perpetuating the popularization of this process. Okay. And therefore, the Court of Appeal will be, you know, more interesting than ever to see how they juggle and wiggle around this most fundamental concern of popularizing the initiative. All right. Trevor.
Cherargei, is this the death of BBI?
Sorry, I think what I can say in this point, of course, these are issues, you know, and I'm happy. Let me congratulate the judges, the judges that delivered the ruling. And I said it in this show on several occasions, that the BBI process was illegal and unconstitutional, both legally and even morally. It was morally wrong to have this process, because in as much as we wanted to ensure that we address issues of inequality, issues of economy, issues of national unity, good governance, it should not have been clothed in the name of a BBI process for an expanded executive. So I want to say that I've read the ruling, and I'm happy this landmark ruling by Justice Nga, Odunga, and the rest, because the issue is, and I want just to summarize, was any constitutional amendment process is that it should be centered or fulcrumed within the people. That is what is, because the reason the BBI was found at fault is, one, there was no public participation. You remember, even in our rallies, we used to say, why don't you give the BBI document to Wananchi to read, the Wanjiku? And you know, it goes back to the question when the former President Moi asked, what does Wanjiku know about the Constitution? But the Wanjiku we have today know their rights. Number two, it was the process. We have always followed the process, and you can hear the talk of my brother Jared, that it looks like BBI is an exclusive document for two individuals, President Uhuru Kenyatta and Raila Odinga, and therefore other Kenyans did not have. Number three, on the aspect of whether the president can become, can initiate popular initiative, is when, you know, I can't lie that I'm ordinary Wananchi, neither Wamatangi, we are state officers. This is the government, and therefore the reason said it started by Wananchi was very critical. Another issue, apart from the process, the issue of public participation, I think also that there is an issue of constituent power, where the argument of the judges was that there should be eternity clauses. And you need to see the intelligence at the drafters of 2010 Constitution. You remember the 1963 Lancaster House Constitution to 2010 was subjected to a process where it was being amended to create an imperial presidency. So having come from that background history of the previous constitution, this new constitution of 2010 must be guarded by creating what we call, the judges call it, eternity clauses, or clauses that you could not, unamendable, because it was to ensure that the constitution protects itself. Because we know after some time you might get a president who is not willing to ensure the constitution works. And number three is that in retrospect, the judges were telling the country, you need to implement the constitution. So what I can say at this point is that we are happy, and of course the people who are aggrieved always have a right to appeal. But I think the legitimacy of BBI process has been eroded, and Kenyans have agreed with us who had expressed reservations. We have been vindicated. You know, when we voted in Senate and National Assembly, many people said we wanted to derail this process. We were not doing for the process, and I am happy that the judges noted that the process. And I want to thank, by the way, the petitioners. They have done a good job. The consolidated petitions by various NGOs and individuals who went to court. That is what Article, I think, 22 of the Constitution of Kenya, where public interest litigation. And I think we should thank them, because it looks like as Parliament we failed. We didn't protect the county assemblies, failed. But it looks like there's some Wananchi somewhere who can sit and decide to act on behalf of the Wananchi, or the Wanjiku. I think number two, of course, I have seen indications. There was a statement that was issued by ANC party leader. We saw ODM party leader, the Maendeleo Chapcha party leader. I don't know why it took around 1 week. He's saying, issuing a statement today. I don't know why my brother and the competitor of Senator Matangi took 1 week to draft a statement in response to this. But it looks like that these people are now selecting another route. That they want to have an IPPG form of inter-party caucus, as to explore a means of using parliamentary process to do constitutional amendment. But we are telling them nicely, even as they exploit that route, because word has it that they want to use parliamentary process by picking various political parties represented, that they, even if they choose that process, they should ensure that we have a representation of the entire face of Kenya, even within the party, because that is, they are trying now, they have realized the BBI route is not possible, is not viable, and I think they want to use the parliamentary process. And number 3 and 4 is that I'm happy, it's like the courts were also telling government that they should know the priorities. We are recovering from an economy that is not, the economy is a recession. Finally, is, I want to ask my brothers in leadership. Let us stop this discrediting, disparaging. If for the last 3 days or after the delivery of that judgment, you could go to social media during the weekend, organize a premeditated press conference attacking the person of judges. You saw even the Secretary General of now limping Jubilee Party, Raphael Tuju, a cabinet minister, issuing a veiled threat that after that judgment, it is shocking. After that judgment, you will need a police officer to escort you to a no. What kind? If we didn't have a lame duck president, Cabinet Secretary Raphael Tuju should have been fired, because what if, even if something, God forbid, happens to a judge, by the fact that you have issued a veiled threat, and I think it is not safe for this country to be issuing threats that are against judges. I want to appeal to my colleagues in leadership. If you disagree with a court judgment and ruling, rush to the court, ensure that we have exhaust appellate decisions. And I hope the new Chief Justice, and you saw the National Assembly, that we need to ensure that we protect the independence of judiciary. So that we don't do overreaching. Anybody, and I'm happy Jared and his brothers have said they are going to appeal, which is good. We wish them well.
Obatangi?
Yes, Trevor. I think I would want to start by probably making what I think clear to a discussion like this one on three issues that I think are important, that are cardinal when you're making a comment on this. First, Trevor, let us first be clear as we look at the judgment that the first requirement of our Constitution is that the language used in the Constitution, whatever it is intended to mean, is supposed to be put there in the simplest understandable language. That means that that Constitution is not intended to be either read and understood by judges or justices or lawyers or technocrats. It is supposed to be understood, known at the simplest level. It is written for the ordinary mwananchi. That first we must agree. Such that every time when we speak matters of Constitution, it doesn't look like it is something that has got to be spoken about. You read that book and then you have to take it to the most learned person with 10 PhDs to tell you what that law means. That is one requirement. Number two, let us also make clear one reality and truth, that the very judicial system that we not only have ourselves, but the world over recognizes in its own structure. That is why you have a lower court, that you have the high court, you have the appellate court, you have the Supreme Court. It recognizes and respects the possibility of error of judgment by any judge, any magistrate, including the very essence of the interpretation of law. And that is why you have those remedies provided for, that indeed a judge or judges can make this judgment and they are wrong, or they have an error, they have made an error in its interpretation, and it is recognized that they can be wrong and they have a right to be wrong. You get what I mean? So it is important for us to make clear that. And then thirdly, is to also then underpin the necessary that has been said many times, that then once that judgment has been made, then it is important to respect it, whether in your perception you find that it has an error or doesn't fit according to your own interpretation, and then you move onwards. So in my comment, I would first say, from my thoughts and my understanding, Trevor, that I think, as I respect that judgment, that the judges who sat in this panel, my perception, my view was that they over-obsessed with one aspect of that of the whole theory, and that is on the question of a popular initiative. I think they were obsessed on that issue. And if you listen to it, because I listened to it quite a few times, you find that they spent a lot of time describing what popular initiative is not. But they did not at all, in any of the statements, say what popular initiative then is. Because, you know, you could say this is not, it's not supposed to be this, is not supposed to be that, it is not supposed, but then you have to say in your interpretation, so that then it aligns with what you are going to be saying in your judgment, then what is public participation? They should have been able to define that clearly. Then you can go along with whatever they said. And so I think from where I sit, respectfully to the judgment, I think it mistook the initiation of or the beginning of that process and the difference that is made by the Constitution by availing the two methods of, or the two ways of amending our Constitution, either through a parliamentary initiative or a popular initiative, that it does not mean, in my view, that once you initiate or initiating the process is tantamount or should be interpreted in the context of that when Trevor in a blue jeans or in an overall initiates this process and in line or rather together with another one, that is what you would call a popular initiative because it was initiated by a guy in blue jeans. Or it was initiated in a field somewhere by a crowd. That is not what popular initiative should be. And that is not, in my view, what the Constitution even premeditates or thinks. It is the route that idea takes. That do you choose to initiate that idea, whoever you are, and then subject it to popular vote, popular will, and popular decision. And that is why it goes to the referendum. As opposed to a closed-door system whereby you find that if it is the parliamentary initiative, it will go through Parliament. So I believe in that misconception, and I say that with due respect, then all the other errors occurred subsequently just from that thought. And then maybe...
Are you aware of this IPPG route that Senator Cherargei is talking about?
Yes, I'm aware, and I would want to finalize with it, but let me say just two quick things. First, why I hold that view, I listened to the judgment, and there were some terminologies that the judges used inside the judgment. For example, I heard the judge, I think that was Justice Ngoge, repeat twice that if this kind of scheme, and underline the word scheme, is allowed to succeed. Now, once you use the word scheme, for example, that shows that you have premeditated, that there is no goodwill or good intent. You get what I mean? And so it looked like, with due respect, that they had allowed the prejudice of other matters maybe to have already
influenced
their decision. So I believe that there's a way forward. I don't want to narrow it to only the IPPG route. Definitely, even an appeal in the Court of Appeal would work. And then at the end of the day, I believe that Kenyans, what they want to see is if all the issues that had been suggested in the BBI process and the initiatives, are they going to be useful to the people of Kenya? And my view is this, that that decision should be made by the people of this country. That the people should be able to have their say, as we did in the first place when we gave ourselves the Constitution 2010. Do we want this to be part of our supreme law or don't we? That decision is very difficult to be made by our Matangi and Trevor and Cherargei here. The best way is to let that decision be made at the appointed level by the Constitution itself. I know there's the discussion, as Cherargei has said, that we can use the parliamentary route and maybe have some of the proposals passed by Parliament. It is also an alternative, because there's some of them that can be dealt with at parliamentary level. But if eventually you are going to go to a referendum with some of those issues, then why not take all? Isn't it best that way? But I also want to appreciate the point that was made by my presidential colleague, Governor Motoa, that indeed it is important. He made a point, sorry, it escaped my mind, but there's a very good point he made there when he was speaking about the approach that the judges used. But let me skip it because it escaped my mind. But finally, let me just say that I believe the way forward is to ensure that what the people had begun is ended by the people.
Okay.
On the question of, and this is the last question that maybe, Trevor, I would want to pose. When does the president cease to be the president and referred to as the president, even in the context of judgment, for example, excluding the provisions of the Constitution whereby it says that you can sue him in his private capacity? And I was asking myself, for example, if you're addressing Justice Ngoge, at what point do you call him Mr. Ngoge when he's still the occupant of the office of Chief Justice? Of Justice, you know, of the High Court of Kenya. I mean, you see, it would be in very, very, you know, extreme circumstances that you could find your tongue, that you would be saying that, but Mr. Ngoge has said this or done this and that and that. You know, whichever way, because as long as he is in that office, if you perceive him and speak about him, you don't, that line is so thin that you cannot expand it to have a Mr. Ngoge and a Justice Ngoge. And I believe that's what I'm saying, that even the impression they give, for example, when they were referring to the president as Mr. Uhuru, I think it brought in that tinge of feeling like they had some bias when they were speaking about it. Maybe in my thinking, they may have wanted to bring about the differentiation that says that, yes, you can sue him in his private capacity. That could have been the intent, but then the effect and the consequence was wrong at the end of the day. And I believe, finally, we respect what they said. Let's move on. Let's go to the Court of Appeal.
Speaking of moving on, this might go all the way to the Supreme Court, and I'd like to hear what Governor Mutua has to say about this. And let's change that topic now into Martha Koome, who's now the Chief Justice, just awaiting swearing in, passed by the JLAC, adopted by Parliament, and now appointed by President. This could end up in her desk. What should be the priority of the judiciary going forward, Governor Mutua? Because, you know, at this particular point, there seems to be very high-heated political rhetoric, and also they are going to be in the focus. And she's taking over right now. What should be her priority list looking like? Because even this BBI case may still end up on her desk.
Well, before I reply to your questions, because I've been taking extensive notes as my colleagues have been speaking, just three quick points. Number one is that I want to tell my good friend with a colored tie, Senator Chirangai, that Maendeleo Chap is a party based on ideology, what Senator Matangi was talking about. So we don't make decisions with just the party leader. We consult, and we've been consulting our people from the ground so that when we speak, we are not speaking the voice of people holed up in an office or boardroom. We are speaking the voices of our supporters, of our team players, from all the way on the ground. You don't want to have that knee-jerk reaction that you see with politicians who just comment for the sake of commenting so they can get into headlines. Number two, it is very important to respect the judiciary. We need to fund the judiciary properly. We need to give respect to judges when they give their judgments. It doesn't matter whether you agree or do not agree with it. You shouldn't be seen to be threatening a judge. Let judges do their work. I hold these judges in very high esteem. I look at maybe Justice Odunga, who I have taken a habit of reading his rulings, and he tends to be very, very fair judge and very, very judge based on the law. So, you know, there must be a reason why judges make a certain decision. If you have a problem, appeal, but do not attack a judge. It is not personal. Walikuwa kazini, and yes, you may see there were some biases in them, but some of them did their things, but let's respect the judiciary. And as I come to conclude on this point, it's quite interesting that my good Senator Chirangai called Uhuru Kenyatta a lame duck, which goes into the thinking. No wonder the deputy president keeps on opposing what the president does. They don't respect him anymore. They think he's a lame duck. And that is something that is given to a person who has lost an inability to rule, or you think that he's on his way out, so it doesn't matter. So maybe President Uhuru Kenyatta needs to assert himself. And when it comes to this issue, talked about the IPPG, maybe it is important to also for Uhuru Kenyatta to realize that when you sit down and you talk to people and you agree on a position, you need to follow up to make sure that your people carry out what you agreed upon. And I'm speaking about this because there's a meeting we held in State House where we discussed a few things, some changes about this BBI referendum. Raila was there, I was there, the party leaders were there, but the changes were never affected. The ideas coming from our people were never affected by the president's men and women, which now makes him look like a lame duck. So it is also a bit of housekeeping that the president needs to be able to do these things. Now, when you look at this case going all the way to the Supreme Court, and I think the very important point that will need to be discussed is this issue of when do you cease being a citizen when it comes to the issue of, when you say it's a popular initiative. Now, the civil society, now those are okay. If the civil society goes out there, demonstrate, they collect signatures, it's okay for them to have a so-called popular initiative. An elected leader who's been elected to represent people in the villages, others, now by being elected, you lose the power to bring a popular initiative just because you are elected by the people. But a civil society person who is elected by nobody, not even their mother, is okay to push the initiative. So we need to have a balanced country here and say that once you're born in this country, whether in the civil society, whether you are an elected leader, you are a citizen of Kenya. And so you have that. So that's an issue that I expect to see when it comes forward. When Mother Koome is taking over the judiciary, it is going to be very important for her to be able to set up rules and procedures. I remember the late Honorable Michuki. When he took over power, he did not reinvent the law. He just went and looked at what the law says. He put it all together. And he was able to come up with the Michuki rules. Why? Because all he did was to make sure that people got it properly, got the systems moving the way they were supposed to be. That's what Mother Koome needs to do, Honorable Chief Justice Mother Koome. But talking about Mother Koome, I don't know whether, Trevor, you're a smart guy. If you look at the headlines in the newspapers today, if you look at the Standard up there, they're talking about full in-tray waiting. If you look at the Nation, talks about full in-tray. You look at People, says full in-tray. You look at the Star, full in-tray awaiting. Now I'm wondering, as a journalist who's worked in a media house, are you telling me that all the sub-editors were thinking of the same headline when they thought about Mother Koome? The full in-tray awaits. It seems to be in all the media houses. And I'm asking myself, does this mean there's a corruption that goes on in media houses where headlines are fed to them by people? Because that's the conclusion I have. Maybe it is something that the gurus like Mutuma Matthew, Linus Kaikai, and others who run media houses, Akina Pam Sitoni, need to look at. How do you have the same headline running in all the newspapers? How do you have the same stories? Which comes back to the point I was making earlier on, that things in this country are rigged by actually secluding people. You look at the headlines, for example. You look at the pictures used. It is the same people. They say, yes, we are selling newspapers. It's not about setting newspapers. They are setting an agenda. Is this agenda being set because as journalists they are the fourth estate, or is it because they have been compromised? How much compromised, how much are leaders compromised or are editors compromised to just favor a few people and seclude others as we go forward? So even I met a diplomat the other day who was shocked, and from Europe, who was telling me that when you look at the newspapers in Kenya, when you look at the news, you would think Kenya is run by one or two families or one or two people, because others who speak points are secluded by the same media, which would not happen in a Western country. And these are people who are trained. So something for us in the media fraternity, being one of them, having come up as journalists, need to think about. Okay. And lastly, it was quite interesting. Maybe Senator Cherangai can tell us this. Mheshimiwa DP Ruto, who will be my main competitor in 2022, God willing, whether it's a new constitution or otherwise, because we plan to defeat him regardless of which one, he said he's neutral when it comes to BBI. Very neutral. But then we saw the people aligned to UDA and his side voting against the BBI in Parliament. And then he was one of the first knee-jerk leaders to come out and derail the BBI and support the judiciary and say, let us finish this. So he exposed his colors. And I'm telling him, please, my main competitor in 2022, you need to be man enough to actually take a stand. If you know, you know. If it's yes. Hii mambo ya kukaa hapa katikati kama fisi, utapasuka miguu, taking both parts. So let's be leaders who take a position and stand to a position. Don't pretend you are here and yet you are here, alafu kikienda pande yako, unasherekea kabisa. So as leaders, and this is the problem we have in this country.
Yeah.
People are all watermelon. You know, it's you're here today, you're there tomorrow, because it's about you. It's not about the people. It's not about the unemployed youth. It's not about changing this country and having political parties and positions of ideology, not just political favoritism.
All right. Jared, what is Martha Koeme's entry, according to you? Because there's so many things coming up. The judges haven't been sworn in. There's also this issue that might end up in her desk, and she's just coming through right now. What should she prioritize?
Well, thank you, Trevor. Firstly, allow me to delve into a matter that my friend Honorable Chirage alluded to, that Parliament may hijack the process at this time on the BBI issue. If the impounded judgment is going to hold and it's anything to go by, then in their paragraph 473, they tried to isolate two key issues. One is the protected clauses of our laws and the unprotected clauses of our laws. And they did say that the protected clauses cannot be tinkered with by a parliamentary process. It has to be subjected to the people. And they did say that it should be a bottom-up, but what they thought is happening is the top-bottom approach of amendment of our laws. So there are unprotected clauses which Parliament has also delved into, has failed 3 times, like the gender representation. So I do not think that Parliament will hijack this process and make definitive changes in our laws with the potential to affecting how we relate with our common people on sovereignty. And that is why the referendum clauses were put into place.
Yeah.
And they also argued that, you cannot have such amendments without Constitutional Amendment Act enacted by Parliament. But, we will come back to that when we will be delving into what is happening in the Court of Appeal. Now, I do not think, when I read the newspapers so far as the entry for Madam Martha Koome, the new CJ, I thought there were a backlog of cases in the judiciary. But look, reading this into detail, I saw basically nothing. Because when you talk about entry and courts are meant to dispense justice, I thought that was it. But, they're talking about, the 40 judges that you have already talked about.
Yeah.
But she needs to sit down with the president so that we know exactly why there has been this inordinate delay to put these 40 judges at work. Today, we have about 12 judges only in the Court of Appeal. And therefore, there is a huge shortage that ought to be filled within the shortest possible space of time.
Okay.
And if Judge Koome will be, taking oath of office, her first assignment should be to have a sitting with the president and understand firstly whether the names really got to the president from the Judicial Service Commission.
Okay.
And if they did, what is causing all these delays? And if there are certain judges who are not properly vetted and there is substantial body of evidence that, that puts them into trouble, then those should be isolated and the clean ones should be appointed so that the dispensation of justice can go around.
Okay.
The other aspect that she really has to work on is the relationship between the judiciary and the president, and the presidency or the executive. After Judge Maraga's very infamous ruling of the presidential petition, it came out that the executive was going to delay any sort of relationship with the judiciary. They talked about revisiting certain issues, subjecting the judiciary to budget cuts, and just putting them to suffer. So she needs to mend these differences so that judiciary and the executive, which are core arms of government, can work as one. If there are pending issues with the parliament, which is the oversight body and the budget-making body, even for the judiciary, she needs to move very swiftly to meet with the speakers of parliament, probably meet with her, the committee that oversights them, which is JLAC, so that there could be harmony and cohesion as these charges had duties.
Okay.
So for me, the intra is more about administrative issues than just what is the core mandate of the judiciary, which is dispensing justice, Trevor.
All right. I'd like to hear your views on two other issues, Muturi's coronation and Wajir impeachment uproar that's been out there. There's been, he was impeached, gazetted, and another one sworn in really fast. But I want to get your views on Martha Koeme's entry. Very, very brief, just one line each, because we have two more topics to go. We'll have a longer session in Parliament.
You know, the issue of Martha Koome does not come to the Senate. And you know, having been the chairman emeritus of Justice, Legal Affairs and Human Rights, I've worked with Judiciary for almost 3 years before I was de-whipped, is that I can say a lot about Judiciary because we did interact under David Maraga and I didn't understand their problems. But in respect of time, I think what I can say, although I've seen Muhuri, Muslim human rights, they say if she's fully appointed, she should not sit in the Supreme Court when the BBI appeal goes there. But those are discussions that we can have in another day. I think what I can appeal to Justice Martha Koome is that we wish her well, and she has broken the ceiling glass, and I think for anybody else, we would want to see her succeed. And from where I sit, the future, in fact, it is very tough for her because we are entering into the electioneering period. We are entering into the succession politics of President Uhuru Kenyatta. And I didn't advise her that she needs now to have the steel to be able to withstand, because there will be a lot of issues here and there involving judiciary going into the future. But I hope, number two is that I agree with Jared that she should engage the parliamentary committees, especially on jail, and the speakers. Because you remember, and then when I was the chair jail, like we did move to High Court to challenge 24 legislations that had been passed without the consent of the Senate. And I think it is important that we work together for the benefit of Kenya. Number two is access to justice. I think we have discussed this and over. With this COVID, how do you ensure that people in Nyatike, in Nyakach, in Marsabit, in Mandera, how can they be able to access justice? And I think she needs to focus on that by ensuring that we get appointment of 41 judges, by ensuring that there is ICT infrastructure in place in almost all courts because of the COVID, by ensuring that there is development of law, that is the legal jurisprudence. We would want to see that happen, and by ensuring that the courts function for the benefit of wananchi, because even when you look under the Constitution, judicial authority is derived from the people. So I want to call upon her, as we wish her well, that I don't know whether there is a full entry, because we are aware there was an acting DCJ, Philomena Mwilu. So I don't know whether there was any full entry, but we want to see judiciary functioning. And I want to appeal to her that as she protects the independence of judiciary, the judiciary also should be ready to be criticized constructively, but not to attack them, so that if judgments and rulings are not agreed upon, it should allow. Finally, is that to appeal, even as the appointment of Martha Koome as the Chief Justice coming to force, we can have a lady DCJ. So what is, I hope somebody somewhere is not thinking of saying now let us remove the DCJ who is a lady, because we have a lady who is, let's allow also women to lead. Like judiciary would want to see a Chief Justice who is a woman, a DCJ who is a woman. Let us allow them to run, and then we see how the leadership is being done in judiciary. And I think, I'm not saying because they are just women, it is because they are qualified to be in those offices. I think that is, and we wish her well, and we hope to see the better from, but I'm happy finally. I had followed when she was being questioned that how does she feel now that she comes from the same region as the president and anybody else, and in spirit of regional balance. But I'm happy she said she didn't choose to be born anywhere or in Mount Kenya, but she said she will be the Chief Justice of all Kenyans, and that is what we want to see.
All right, well, Matangi, what do you think, what do you wish she prioritizes as she takes over the helm?
Trevor, can I first defend you?
Go ahead. With the titles.
No,
I mean,
because, you know, my colleague in the presidential race
Race,
asked a question whether he doesn't think that he has you know, I don't know whether you are a smart guy, but I wanted to come to I wanted to come to your defense and say you are not only a smart guy, you are brilliant. And
Thank you.
but of course it is. I'm you know, sometimes when presidents are speaking, they speak quickly. and sometimes I could fall in the same trap. So I know it was just an innate. But you know, one thing, Trevor, I wanted to, because that's what Cherargei finished with, and I think it's important because as we are speaking about the Chief Justice now to be Martha Koome, that question of criticism of judgment versus that criticism of judges, I think that has got to be spoken of very, very clearly, such that then it doesn't come out that that people should be muted, that they cannot speak about a judgment that has already been delivered, and look at its pros and cons, and you know, can it be held to the high threshold of meeting what the general public good is? I think that needs to be made clear, such that every time when a judgment is made and then there is dialogue amongst the people, then the judiciary doesn't unnecessarily become jittery, that there's that kind of discussion. Remember, and big decisions are made, and a lot of talk is there. Remember, like when there was the presidential race between Al Gore and George Bush, finally it had to go to the Supreme Court to make a determination, and that's how the presidential race was going to be determined. It became a big subject of talk, even after the judgment was given to the favor of George Bush. You know, and that's how he ended up becoming president in a very close run where he lost the popular vote. And people will definitely be able to speak. So I just want to urge our judiciary that sometimes also it is also good for them to be open to criticism, constructive criticism, so that they can also look at where do they need to correct things. It does not mean that within the judiciary also that they are 100% to 100% of the most righteous and best of people. I mean, they are just like us everywhere else. Now coming to Justice Koome, I think I'm impressed by her, you know, to say the least. I think I've been following, you know, her through when she's gone through all the stages of being vetted, and she's come out as a very sober person, somebody who is focused, and she also exudes a very good and attractive sense of humility. You know, and that's good for somebody who is going to occupy that position, because one of the things that you want is a Chief Justice who is able to be able to speak to all her people, you know, gel with them, and then lead the judiciary for what it's supposed to be. I wish, and I would want her to prioritize the continued you know, digitization and efficiency enhancement within the judiciary. Remember, when Willie Mutunga, former Chief Justice, came to that office, he said that he was going to embark on the process of ensuring that cases are going to be expedited the fastest possible. And he did try and started there. Then it was continued by Maraga. I would want to see Justice Koome, the Chief Justice incoming, make that top priority, such that people can have their matters decided by courts as soon and as fast as practical.
All right, we run out of time here, but I'd like to hear your views. Just one line each on this issue of Muturi's coronation. It was such a big issue. The Speaker, Justin Muturi's seclusion for rituals ahead of Uhuru's succession. Muturi is to be crowned the Mount Kenya spokesperson in Murang'a on Saturday. And Wamatangi, I'll come to you on this last because you have the cultural understanding of it. But just one line each before we take closing remarks from Governor Mutua. What do you make of this entire ceremony?
I think for me, it's an issue of where we as a country. When you look at the Muturi coronation, a man I really respect. He used to work in Machakos many years ago. He's proven himself as a good politician. But you ask yourself, why is he being crowned? Is it a bottom up or is it a top down? And who decided? Did it come from the voices of the people on the ground that this is the person we need to be our spokesperson up to the top? Or, you know, how does it happen?
Yeah.
So it's just a question to ask. And so the other thing to ask is that really, do we really need these spokespeople of certain groupings in our country? Is that where we are? When you look at our young people who are currently unemployed, it doesn't matter which region you come from. Today you are suffering. You have no jobs. There's no money in the pocket. People are sleeping hungry. Infrastructure needs to be improved regardless of where you come from.
Yeah.
This country has issues. So when you get to this culture of tribal kingpins, of groupings, kingpins, we are going back to where the colonial powers put us.
Yeah.
That African heads, we have to just align them to their tribes, align them to their groups, and they will disregard ideology, ability,
Yeah.
and be able just to go forward. And lastly, to ask ourselves, we need to learn from Tanzania. Look at President Suluhu. She comes from a very, very, very small ethnic group. President Kikwete, very small ethnic group. These leaders are not judged on the basis of being kingpins of their tribe or their regions.
Yeah.
They are judged on having the ideology of Chama cha Mapinduzi,
Yeah.
or having the ability to lead their countries.
Okay.
So for me, it is neither here nor there. It is important
Yeah.
to that grouping maybe, but it is a reflection of the past, not the future.
Okelo, what do you think? Because it's not only Muturi, to be fair. We've seen this with all the other leaders. We've seen DP Ruto being crowned the area kingpin and also the spokesperson. We've seen Raila Odinga being crowned an elder. This is not a Muturi issue. I'm just saying, how significant is this process to the general electorate?
Well, in advance, let me congratulate my brother Muturi for his impending coronation coming up on Saturday. I'm very happy for him. He's a very good friend of mine in Parliament. I know he has what it takes to lead a people. I mean, leading 349 members in the National Assembly isn't a walk in the park, with people of varied interests and varied backgrounds and all that. But he has able to shepherd us into the direction that the law envisaged, and I wish him well. It is the nature of our politics, Trevor. We are in a country where your background, your ethnic alienation is key in order to move to the next step. And with President Uhuru Kenyatta exiting the stage next year, there seemed not to be having a front runner from the Mount Kenya region or somebody who will be advocating for their plight. And that is why my brother may have seen this opportunity. He began by his own small tribal grouping called Meru Onjurinjeke, and he was coronated just a while back, barely 2 months ago. And on Saturday, he has now widened his tentacles to incorporate other sectors of the gamer community.
Yeah.
Therefore, putting him into a higher pedestal in terms of negotiation.
Yeah.
So that even if there will be no president coming from the Mount Kenya region, there will be one who will be speaking about their issues and asking for, favors, in quotes, for the people from the Mount Kenya region with the president who will be in office. How I wish, just like my brother Mutua has said, that we will ride ourselves above this certain times very partisan, boxing into village cocoons and move out and just become nationalistic.
Okay.
But we are still far away from getting there. That is why we still have to concoct certain things around our tribal groupings. But again, I wish my friend Muturi very well.
All right. Cherargei, just one line. It's not such a...
Yes,
it's a cultural thing.
It's a cultural thing. I would say I want to wish JB Muturi very well in the process. I saw Wazee is on seclusion, and I want to wish well. I think as Africans, we should be proud of who we are. Our cultures are diverse, but there should be unity in our in diversity. And I am told this weekend in somewhere in Muranga, I've seen he reported somewhere that the process will be completed. I wish him well, and I remember when the deputy president was being given blessings by the Talai clan, and many people accused, calling names and saying this is not the right thing, it was something that was not good and everything. But we must recognize from where we come from. I agree with Jared that after the process, we can now, that is just for identity, but going into the future, we must build a nationhood. we would expect leaders, even if you have been coronated, that is your identity and recognition of diversity. But we go together into building one Kenya, where regardless of the tribe, the culture, the religion, we build one united, indivisible country going in the future. So we want to wish him well, and I think I made a comment when he made that ruling on BBI on not amending, and I said my predictions has come to confirmation that he is interested on higher office. When I said, many people did not believe. And you can see, Trevor, whenever I come to the State of the Nation, anything I say here should be taken seriously, because I come from the land where we can see the future.
But thank you very briefly on this, because you have the cultural understanding.
You know, it depends a lot on which direction you are looking at when you're looking at the future. Because if you're looking backwards, you could be looking at the future as it happened. Anyway, let me first start by telling my good friend Jared Mweshimua, on the other side, he began by saying, as he congratulated Muturi, that there is likely not to be a presidential candidate in Mount Kenya region. I want to tell him to watch this space, because one is sitting right here.
You're running.
But anyway, we are definitely going to be in the contest in Mount Kenya region. We are going to be having people running for president. And in our democracy, it should not be ruled out. It cannot be ruled out that indeed somebody from Mount Kenya region can be president. That is what democracy is about. And so let's put that to paid. On the coronation of my friend and brother, Justin Muturi, I want to say that first, he's done a good job. He's led the National Assembly for 2 terms consecutively and successfully, and he's made rulings which are good, fair. Some, of course, have been criticized. That's the course. That's in the course of leadership. But I think he's generally done a good job. And being from the Mount Kenya region and the stature he has exuded, definitely he befits to be one of the people that we are going to be looking at and seeing whether he can play a pivotal role in the leadership of the region. Of course, we are many of us, and there's no shortage of leadership in Mount Kenya region. So I just want to wish him well, and I believe that if that event is open, most of us would want to support him and be there, and vice versa. When I'm also being coronated, I'll also invite him and invite him. This is how it works. But anyway, I think Justin Muturi is a sober leader. He's a good man, and he's capable.
All right. That's why we have to leave it for now. Thank you so much for making time. Dr. Kimani Wamatangi, Senator for Kiambu and Majority Whip, Dr. Alfred Mutua, Governor Machakos, Honorable Samson Cherargei, Senator Nandi, and Honorable Jared Okelo, Member of Parliament Nyando. That's why we have to leave it because of time. I think we have some feedback from you. Should we run them really fast? Should we run them really fast and see what you're saying? Let's bring them up and say what you're saying on Twitter here before we finally close. Basho Alas says, democracy, yes, but it's an indictment on Jubilee as the party that brags having majority in parliament losing to PEP. Mount Kenya is also tired of the oligarchs and hegemony of the few. 2022 should be about us, the citizens of Kenya. Okay, Jacob Obere says, mine can't call it Jubilee loss. What we witnessed in Juja and Bonchari is contrasting to what is known. This by-election reflected real informed electorates, no matter what systems brings. On top, the two are cosmopolitan constituencies. Okay. Kiprono Abraham says, politicians should not sacrifice this country for political gains. The BBI judgment is now famous to Kenyans because it brought a lot of reprieve to Kenyans, but our political elites appear grieved. Leaders should invest energies for economic recovery. All right, Agumba Steve says, all the best to the new Chief Justice. One thing she must know is that our society is corrupt, and guarding the independence of the judiciary needs more guts. All the best. All right, that's where we leave it for now. Up next is Breakfast Tips.